I hope you've managed to grab some refreshments, and if you haven't, please, please do. For those that I haven't yet met, my name is Nadine Russell, and I'm the Executive General Manager in Telstra Enterprise for Local Government, Corporate and Community Services, or as we call ourselves internally, it's not really externally, Team Lococo. But we really are very grateful that you've given up your Friday afternoons to join us. So on behalf of LGPro, Nimbus, Gadens and Telstra, we really hope that you find the afternoon really informative as we work through with you on how to navigate wage compliance with confidence. It's very topical for a lot of industries, and we are finding a lot of local government customers are very keen to explore this topic with us. So thank you for joining us. But before we do kick off, I would like to acknowledge the traditional custodians of the land we meet in beautiful Melbourne today. So the Wurundjeri people of the Kulin Nation, and pay my respect to their elders past and present. So team, thank you all again for joining, and I'll hand over to Sue Wilkinson, the President of LGPro.
Thanks, Nadine. So on behalf of LGPro, I also would like to acknowledge the traditional owners of the land on which we meet today, the Wurundjeri people, and pay my respects to elders past, present and emerging, and also extend my respects to any traditional owners that may be here with us today. On behalf of LGPro, thank you everybody for coming, but a huge thank you to Telstra. The partnership with Telstra and LGPro has been a long and enduring one, and so important. It's been a real privilege to get to know the Telstra team in my short period as president, and we value the relationship so much. We had a meeting, I don't know, a little while ago, a few weeks ago, talking about what this session might involve, and one of the things that we agree on with Telstra is that Telstra has helped the sector, because of the nature of the work and the sort of extensive partnerships into the greater world, really helps local government lift its head a little and think about the issues that are coming towards us. So I think that's the real opportunity here. So Matt wanted me to talk about, I've got this reflection about 5 years ago, 5 years ago I didn't have anyone working on AI or let alone cyber in my organisation. So the world is changing super quick. And Telstra and other partners have really helped us navigate that. Wage compliance is something that is starting to exercise the minds of local government, I think. I was saying earlier, our portfolio is so broad, and I reckon there wouldn't be a local government in Victoria that doesn't have an element of their staff that still submit paper timesheets. So, you know, now, probably wouldn't have 2 or 3 years ago, but now I start to go, well, that's probably a risk. So it's not that there's no deliberate, but there's so much legislation, so many systems. All of us have really outdated systems. We have staff that work an hour a month. We have staff that work, you know, on different awards depending on what. It's really complicated, and getting it wrong has such serious consequences, not just legally, but also ethically. So I'm really excited to hear the panel today. Looking forward to hearing the discussion. Thank you again to Telstra for having us and hosting us this afternoon. Thank you. Over to you.
Thank you, Sue. Fantastic. Well, thank you all for joining us this afternoon. My name is Glenn Carmichael. I'm the Head of Technology Strategy for Telstra Technology Services. So not an expert on navigating wage compliance, but that's why we've got our special guests here today that we're going to be talking with. So workforce compliance, as you said, like, it's becoming increasingly complex and kind of something that organisations are thinking about a little bit more. And there is a lot of pressure to meet some of the regulatory requirements that are sort of coming in over the top. It can be very challenging to identify risk and defining strategies that ensure to ensure that you are actually aligned with the regulations. So today, some of the topics that we're going to be touching on, there's 5 kind of core areas. So we're going to start off with a bit of background on the compliance laws in Australia and the role of Fair Work. Then we'll move on to talk a little bit about some of the insights that we're seeing in the marketplace and the challenges that customers are facing. Then we're going to get specific to council operations and talk a little bit about the role that wage compliance plays specifically for council ops. Then we'll talk about some insights into effective wage compliance tools and how to stay productive, like Nimbus. And then finally, we'll finish up on time theft and best practices for managing contracts, work hours, and variations. And because I'm a technologist, we've got some experts here to help have that conversation. So here we have Amanda Junkier. She's a partner at Gadens law firm. So she's got 20 years of experience as an industrial and employee relations lawyer. She's worked with leading national workplace relations practices and is also as an in-house counsel for ASX listed organizations, as well as healthcare organizations. Okay. She's acting for corporations and not-for-profits. Amanda's expertise spans enterprise bargaining, industrial disputes, payroll compliance, disciplinary processes, wage audits, and employment litigation. She's got extensive experience advising on complex matters, managing audits, liaising with regulators, and appearing before the Fair Work Commission. And so she's a trusted expert in her field. And then we have Adam, equally impressive. So Adam's, I've known Adam for a long time. He's great. So he's from our technology solutions provider and partner of Telstra at Nimbus. So he's the Chief Alliances Officer at Nimbus. So his key role is being responsible for strategic partnerships, client engagement across the globe, and leading a team of dedicated innovators that drive SaaS solutions in workforce management and compliance. He also has a career spanning over 20 years and has honed his experience in workforce management, and project deployments for clients in Australia and across the world. So his key areas of expertise: wage compliance, award and enterprise agreements, and time and attendance. So extremely credentialed, extremely the right people to be having this conversation. But to set that baseline, that first question, to give us a bit of background, why is the focus on compliance so significant in Australia at this particular point in time?
I might take that one, Glenn. Hi, everyone. Nice to speak with you this afternoon. I think in terms of compliance, there's a bit of a backstory, and many of you would be familiar with it anyway. But in terms of a potted history, the Fair Work Act came into effect in 2009. There was legislation well before that in terms of regulating workplace relations. But what the Fair Work Act did was give power to a new regulator, being the Fair Work Ombudsman. We'll talk about the role of the Fair Work Ombudsman in a little while as well. And what we saw with essentially the introduction of a regulator in compliance space was that you had essentially a regulator on the beat, a policeman on the beat for the first time, and there was more resources to proactively look at how compliance was happening out there in industry. What we then saw through that time period was the evolution of the need to be proactive with compliance, and the regulator really drove some of that work because the legislation has always said that you have to pay people accurately, pay them in accordance with any applicable award or enterprise agreement, pay them in a particular time frame, and ensure you keep records. So that hasn't changed more recently. Where we're seeing this talked about a little bit more in the media is really with some of those larger scale underpayments that were disclosed more publicly. So you will think of Coles, Woolworths had a $400 million self-disclosure a few years ago, which is still going through the courts. You had the ABC, as in the television, the ABC Corporation. You had public and private organisations and companies self-reporting or in court, essentially, and having to disclose their underpayments. So in the last 10 years, we've seen a lot of larger employers either find their own issues and then come forward, and they've had to tell their employees, and through telling their employees, it gets media attention, it gets the regulator attention, or you have the regulator who has been more resourced in the last 10 years to actually proactively go out and do investigations, particularly for vulnerable cohorts of staff. So what we've seen then in the last 10 years is the advent of what the regulator calls enforceable undertakings. So what it says to employers is, if you've got a large-scale underpayment, we'll work with you in a cooperative sense to an extent to avoid litigation, but you enter into these enforceable undertakings. They're public, and it's what we're seeing in terms of those self-disclosures in the media. Through that, I think what you then see is this momentum build and more of corporate Australia, local, state, federal government paying a bit more attention and saying, well, if these issues are happening, what do we need to do to proactively ensure that compliance is a focus, a board focus and a priority, and be more proactive about compliance. Yeah. So when I started practicing quite a long time ago, over 20 years ago, doing a compliance project and doing a review with a client along with an advisory firm, a technology services firm, to actually look at what has happened historically, what's happening now, what are the assurance systems going forward, wasn't part of our practice area. We were looking at discrete underpayment issues that were going to court, which are few and far between, because employees themselves, unless they had the union supporting them, found it very difficult to actually pursue the underpayments. They'd have to go to their employer. If the employer didn't pay, it was really difficult to agitate unless you had union support or could pay for representation. Now what you're seeing is the regulator driving that. They will advocate for the employee or a group of employees. We're seeing more class actions happening as well. And you've got regulator being much stricter with non-complying employers. Then more recently, which has got more attention, is that the federal government decided to criminalise wage theft. It had always been a civil offence, so you could get significant penalties in terms of hundreds of thousands of dollars of breaches. But now from the 1st of January 2025, we've had a criminal framework. Now, there hasn't been a prosecution yet, but there was a lot of talk about it in the last few years. The Liberal government had tried to get that through, but hadn't been. It was so political that it just couldn't get through Parliament, but we saw the Labor government do so with their majorities, which is not surprising given the momentum that had been building up. But what we have noticed out there with our clients is that the criminalisation of wage theft has made it top of the list in terms of compliance activities, or one of the top of the list, whereas before it was a priority, not as significant. But given that directors, office holders of organisations who make decisions about compliance can be held responsible for intentional wage theft, there is a lot more activity in this space now.
Yeah, I'd also re-emphasise that when the Fair Work Act came in what was 2009, that was with the Rudd Labor government at that particular time. So came in with a large swell of new enforceable undertakings, requirements that Fair Work could actually do, both the Commission and the Ombudsman, and they are two separate bodies. The Commission sets the legislation, the awards, the enterprise agreements, but it's the Ombudsman or the regulator who actually has the power to investigate and enforce those findings from that point of view. Obviously, we went through a wave of Liberal governments or coalition governments, but with the emergence of the Albanese government, that's re-emphasised or reinvigorated Fair Work in regards to the engagement. So we'll talk about terms like closing loophole laws, the right to disconnect. I'm sure you're familiar with all of these particular terms. That has been re-emphasised by the Labor government. Now, not predicting what's going to happen on Saturday, but if the Labor government is to continue, for example, the Albanese government has made it clear that they're going to put into legislation that opportunity to actually enforce penalties. So where enterprise agreements are set up or where legislation is being looked at to ban penalty payments or calculations, the Albanese government is going to make sure Fair Work can actually reinforce this. Now, for yourself in operations, think of something as simple as what's the definition of ordinary hours? Depending if I'm in childcare, customer service, other functions within local government. Each one of those under the local government award or your enterprise agreements have different operating times. If I do, for example, childcare, that's one set compared to customer service. If you don't pay me the correct penalty or overtime rate by taking into account a blanket view, that could have an impact in regards to the prosecution. And Fair Work, in my humble opinion, is only going to grow more and more based on if the Labor government is continuing from Saturday onwards.
Fantastic. So that's a really good baseline as to Fair Work. It also is really scary. I don't even have employees, but it's complex, and if you don't get it right, there's serious consequences. So sort of moving on from that, what are some of the effective tools and steps that you can take, like proactive versus reactive sorts of things? Adam, I might get you to start.
Yeah. I'll talk about my experience. One of the luxuries that I've had in the last 20, 25 years, I've worked with a number of councils here within Australia and councils overseas. Probably the biggest one overseas was Glasgow City Council for a good 2-year term over there. So I think it was mentioned before, reactive modelling. Councils are traditional organisations where previous legacy systems, which have worked for many days, will continue to be reinforced. So it is not uncommon still to see manual timesheets within your labour workforce. It's not uncommon for the employees to be doing interpretation of their own time and passing that off to your payroll divisions for payment processing. That's the way things have been done in the past. The challenge we have now is that Fair Work and the Fair Work Act has made it very clear that you are required to keep records for a period of 7 years, and those records need to be clear, legible, and accessible by Fair Work if you are to be investigated. So I'm big on my stories for the people in the room who know me, but I'll give you an example of this. Council, remain nameless for obvious reasons, was very good in its business processes in making sure that it took manual timesheets. They were cross-signed off by the line supervisor. They were cross-signed off by the payroll officer. They were put into the payroll process and people got paid accordingly. Those timesheets, though, were stored for 7 years in plastic buckets. Those plastic buckets were put into the services depot of this local council, where all the petroleum and other goods for services that would be provided were right next door to that scenario. Now, nothing happened, luckily, but imagine if there was a fire, there was an incident. All of those records could have been lost. So that's, a reactive type model from that scenario. Where the environment is now going, and this is all industries, it's just not local council, is that proactive model. Now, you may have systems which are on-premise, you may have appropriate backup systems, but it's that ability to have systems which are cloud-based, having DR systems in place to accommodate those requirements in real times, the appropriate audit and compliance checks that need to be in place, be it the local award or your individual enterprise agreements. That's where organisations are now moving to. Because, as I said before, Fair Work are really grown teeth. They are out there. They are looking for examples. Intentional underpayment, I'm sure none of you are in that position and therefore criminal prosecution would take place. But reckless underpayment is common and the fines now are significant. That's where those companies are going to those proactive models and making sure that they've got those checks or balances in place.
Love it. So that's more around the payment and the tracking of time.
Oh, no.
That's great.
Yeah.
The CEO of Nimbus.
Yes, the CEO of Nimbus can't open a door. So I did not say that. Hopefully that's not recorded.
Yeah. He's all good.
Well done.
Okay.
Thank you.
So it's talking about capturing time,
Yep.
payments. Some of the other detail that you might need to capture, around an employee's time, work hours we've talked about, but breaks, overtime, employee entitlements.
Yeah, let me touch on those scenarios because they're particularly interesting in line with what I just said about ordinary hours before from that point of view. So I'm sure in all your councils, I've seen this many, many times before, you will onboard employees. They may be salary-based employees. You will pay to the conditions of salary. However, hands up, how many of you heard of the Better Off Overall test? I'm sure all of you have. Yeah. Okay. Payroll people in the room? No? Okay, HR, fair enough. So the Better Off Overall test is basically the condition of Fair Work Australia where they will check off if I am better off on the modern local industry award or your enterprise agreement compared to salary. Now, what are the conditions to track that? We talked about in ordinary hours before and about the role. I may be in child services. Therefore, I may have to stay back because there's always that late parent who doesn't show up. I'm one of those late parents, I'm sorry. Therefore, those staff need to be paid the appropriate penalty or overtime. If you don't have checks or mechanisms in place to capture that time and do that appropriate calculation, there's your appropriate risk from that point of view, i.e. have you done the overtime calculation? Now, you may say, oh, well, we pay that person's salary. That's fine. But if I'm going into overtime and it's on a public holiday in certain states, South Australia, for example, have part-day public holidays, which we need to accommodate. Is there scenarios where it may have triggered greater than the 38 hours? Therefore, you've got loadings. What are your mechanisms for capturing and identifying that? So your employee is paid salary, that's great, they leave your organisation. Some of the data that you can see on the Fair Work website now, it's very easy for employees to go on and check what their pay conditions are. It's called the PAC tool. And I've got some data here, I'll bring it up on the screen, or sorry, not up on screen, on the tablet. They had, what was it? 21.2 million people do checks via the PAC tool in the last financial year alone. 21.2 million Australian tests that were done on the PAC tool. So in that scenario, employers can check that. If I don't pay overtime, if I don't pay the conditions correctly and I leave that organisation, I can always report to Fair Work I wasn't paid correctly. And that's when that investigation can actually take place from there.
Amazing. So Amanda, this is so complex. The rules are different per industry. Like Adelaide's making up half-day public holidays, and you've got to account for that. There's a lot to take on. What are the penalties if you get it wrong?
Penalties are quite significant. So the civil penalties go up to 99,000 per offence, so per breach. And now technically a breach can be a failure to pay one payment on a particular day. The courts will take a particular view if there's a continuing underpayment. So often if the rule is configured incorrectly in your payroll system, or the rate is not being captured correctly and being incorrectly paid, whatever the error is, you will find with an employee who's continuing to work that the error will be repeated. So you'll have multiple breaches at the time it's identified. And the courts will take a view about whether it's a continuing breach or whether they're singular breaches. You can see the millions of dollars in fines that one single error can actually cause, because it will be an error that causes a breach on every single shift that the employee works. There are serious contravention fines as well, which are up to 990,000, I think it is, almost $1 million. That goes up every year because the value of a penalty unit goes up. Serious contraventions are where there are essentially there's reckless conduct, so reckless indifference. With the introduction of criminal wage theft in January this year, what we see is the potential for imprisonment of individuals who've been found to have intentionally underpaid for up to 10 years, or individual fines for up to 1.6 million, I think it is. When we talk about intention, though, a lot of employers get comfort in thinking, well, we would never deliberately underpay, so we should be okay. But with a corporate, and local councils would fit within this, where you have an organisational entity that has caused the underpayment, the courts won't look at whether a single officer had an intention to underpay. It might, if it's obvious. That will be more the case of like a small business. You can think of the takeaway shop at their shopping centre, run by mum and dad proprietor. If the mum and dad proprietor intentionally underpaid, then you're going to hone responsibility on that person. When it comes to a corporate, what the legislation actually says is you need to look at what the corporate culture is. There are a number of criteria, including whether the organisation had set itself up compliantly with an assurance framework, essentially. Have you done your due diligence? Have you turned a blind eye to it? Are you on notice of potential issues and you're not doing anything about it? What will be really interesting to see is the first prosecution in this area.
Absolutely.
So the Department of Public Prosecutions, the criminal prosecutor or the federal police have the right to pursue this as an investigation. We don't know, of course, if they're investigating anyone at the moment. I suspect that they are, but what I do think is that this is going to take a couple of years to see our first case, to actually see how they hold responsible a body corporate. Because it'll be very difficult, as I said, to say that someone individually intended to underpay. Most of the errors that we're finding through our work are inadvertent, system-based errors, because it's a set and forget mentality with payroll systems and processes, and the lack of an assurance framework to do continual checks on your payroll systems and processes that support the systems. And so it'll be interesting to see how they prosecute an employer who may not have intentionally underpaid, but did not turn their mind to compliance assurance checks on an ongoing and progressive basis, which is where having the systems and having a review mechanism in place and having the systems to do that is really important going forward.
I think a good example of this is in the last 6 months prior to the new legislation that came in on Jan 1, there was a real rush of enforceable undertaking and self-reporting to Fair Work Australia. And, won't name the industries or the organisations, just pick up the front page news. They're pretty much been on there. But the thing that really grabbed me is on Jan 1 in regards to news article and editorials that could be published within the Australian newspapers, Fin Review, The Australian. The first articles I noticed were there straight away: compliance, new legislations, litigation requirements. So I think there is a focus on compliance. It's half the reason, obviously, why you're here today. But this is not just looking at local councils, it's across all industries within the Australian network right at the moment. And I think, organisations are taking that onus on going, well, yes, we have a compliance responsibility to pay our staff right, but we need to check that in line with our systems, our processes, and just because it's out of sight and out of mind, like payroll systems process and have been processing forever and a day, that validation of audit or advisory work seems to be also increasing within the market as well.
The gasps when that $99,000 number was mentioned.
Can I mention one more scary thing? With respect to underpayments, there's a separate penalty regime for underpayments as well. The fines go up to $495,000 per offence for underpayments for some types of contraventions, or 3 times the value of the underpayment. So if you think about Woolworths underpayment, which is disclosed to the stock market a few years ago and then went to the Ombudsman, Ombudsman was not happy about that and is prosecuting Woolworths for it. The value of the underpayment, 3 times the value of that, is going to be much more than the maximum contravention under legislation. So the legislators actually thought about how do we get the maximum impact in terms of fines, which is really, it's trying to promote and provoke employers to be more proactive in this space as opposed to reactive. Historically, what you'd have is underpayments discovered through 2 ways. An employee would find it and they would say, what about my pay? And an employer will look at it, or you've got a union who will look at it and say, well, there's a group of employees who are underpaid. But bar that, you didn't have a reason, a motivation to go and look. But what we are seeing a lot of our clients do now is actually say, how do we build in, and sometimes they call it a review process, an audit process to check what's actually happened. Now, sometimes, the expression of let sleeping dogs lie applies, but I think the days of that approach are gone because of these penalties that are now in play.
I said it was scary, and then you're like, oh, that's not scary.
But there are ways to get it done. There are ways to address risk. There are ways of minimising risk through continual checks and having essentially an assurance framework that you build for your organisation that has these checks built in. It doesn't mean you're doing a full reconstruction or remediation audit every year. That will be cost prohibitive, but how do you build in some kind of process so that you're continually checking? And if you are investigated or prosecuted, that you can say, we did our due diligence. We did our checks. We didn't turn a blind eye. We had a compliance framework. Now, is it a sample review done internally every year? Is it 2 checks a year? Is it a review of all your rules that are embedded in your payroll system every 2 years or so, or legally reviewed? They're all really great options for you, and you can think of a hybrid approach to suit your council.
And connected to that, so obviously having those processes in place is fantastic, but in terms of what are the requirements around actually maintaining that data and that information? You talked about not putting it in a bucket next to petrol.
That's right,
pretty much.
And I've had a situation where we had to do a back pay calculation because a group of employees at a particular site and their union identified that a particular public holiday wasn't paid correctly, minimum engagements weren't paid. So the next step was to look at, okay, well, for the last, however many years that this might have been happening when the rule changed, which I think was a 4 or 5 year period. A lot of people go to the 6-year statute of limitations period, but sometimes you have to go back a bit longer as well. They said, where are the records? We need to check. And there were physical timesheets. And there was a flood that affected the storage house that held the records, and we couldn't retrieve some of the records. So the Fair Work Act actually says where there's evidence that can't disprove that the payment was paid, there's an assumption made in favour of the employee's claim. So if the employee says, I worked every public holiday for 4 hours at least, and you don't have records to disprove it, you might have to use that assumption to actually pay it. That's what the courts would look at. So records are really important, 7 years at a minimum, and data integrity is really important here. Of course, there are still employers who use paper-based timesheets. There are reasons for that. They store it electronically as well. But I think the time to modernise some of those practices is now for those reasons. And the courts will understand. I mean, if you don't have the records because you've had a an event like a weather event that's destroyed them, the implications, maybe the penalty for failure to keep records will be lower because the courts will consider your culpability, etc. But the problem is disproving the wage claim is going to be difficult.
Yeah. It's four elements under the Act itself. So as Amanda said, record keeping for 7 years is mandatory. That's obviously in line with other requirements. Accessibility, as I mentioned, is key. You've got to have them. They've got to be in English. They've got to be accessible by Fair Work if they're engaged. Accuracy. The records cannot be altered or adjusted without mutual consent with the employee. So whatever was captured and paid to, that's what you need to do from that point of view. And then there's obviously the content as well. So obviously employee ABN pay details, hours of work, things along those lines. I mean, as I said before, with my stories and examples that I've seen over the years, we had a similar event with a client. This was an overseas client in this case, where they had a very robust on-premise solution, did time capture, did the award interpretation in their environments, but it was on-premise. They did external backup drives, which the CTO would take home once a month and store somewhere in a secured safe in their environment. Now, the problem was one of those backups got corrupted, and guess what? They needed to do an audit accordingly. Primary system was offline for maintenance. They didn't have accessible records at that particular time. So once again, that's one of the challenges that they had in that type of scenario.